If you ask a room of senior executives who's to blame when AI gets it wrong, they'll look for the nearest low-level operator or employee. The reason's simple. You can't ascribe personhood to software. But that instinct needs to be rethought because the burden's shifting to the organizations. Courts and regulators now have a named set of standards that turn "we didn't see it coming" into a citable failure. Let's talk about how that shift actually works. Welcome to the Enduring Advantage podcast. I'm your host, Zachary Alexander, and this show is for the people running plants, fleets, and hospital campuses, where the AI conversation is mostly being had by vendors and third-party consultants versus the people who care about keeping the place running after the next wave of retirements, rifts, or whatever comes next. I want to be direct about where we're headed. The reason is the burden's moving from the operator to the organization isn't a vibe. It's three legal doctrines courts already use, a real court ruling that's already happened, and a named list of controls regulators already check. That's the case I'm about to build. By the end, "we didn't see it coming" won't be where you start your defense. Let's start with the whole personhood thing. Every major source agrees AI systems have no legal personhood. They cannot be sued, charged, or held morally accountable. Responsibility always traces back to the humans and the organizations around the system. I believe the personhood is at the heart of why the Anthropic and the Pentagon fell out earlier this year. The Pentagon wanted the Claude model to make life or death decisions autonomously without any human intervention. Just an aside, you'll see later why this is a bad idea. Right up there with, "I was just taking orders by the German soldiers in two." Anthropic said no, because they didn't want their model to be held responsible for any atrocities that may have been committed because it lacked the proper context. Now, before I walk you through any more of this, I want to start with our standard disclaimer. The podcast is published by Enduring Advantage LLC for information and educational purposes only. It does not constitute investment, legal, tax, or business advice, and nothing in it should be construed as a recommendation to buy, sell, or hold any security or to take any specific business action. Viewers should consult their own qualified advisors before acting on any information presented here. So if it's not the AI itself, who exactly is on the hook? The consensus that's forming splits it into roughly 5 layers, based on who controlled the failure point. Developers, they're liable for a flawed model, bad testing, biased training data. Deploying organization, that's your organization if you're the one who bought it, configured it, and put it in front of your team. You're also liable for oversight and monitoring once it's in live. End users, share responsibility if they relied on the output without scrutiny. Data providers, if bad training data caused the error. And regulators, who aren't liable for any single harm, who set the standards and influence the regulatory environments. If the regulatory environment seems lax or suffocating, the regulators take the heat. Notice where most of that weight actually lands. Once a system's in production, not on the company that built the system, on the company running it. This isn't a theoretical. In May 2026, Germany's higher regional court of Hamm ruled on a chatbot running on a medical practice's website. It told customers the practice's 2 doctors were specialists in aesthetic surgery. They weren't. The company's defense was straightforward. The chatbot said it, not us. The court rejected that outright. The doctors running the company were held responsible for what their chatbot said, full stop. It's on appeal, but the law firms tracking it already telling their clients the same thing. If you're in a regulated industry, healthcare, finance, insurance, anything with a license on the wall, you don't get to blame it on the bot. And it's not the first time a court's landed there. A Canadian tribunal reached the same conclusion about Air Canada's chatbot after it gave a customer bad information about a bereavement fare. Based on additional research, since there's no unified AI law yet, courts and regulators fall back on three existing legal doctrines, depending on who controlled the risk: negligence, product liability, and risk-based tiered liability. Let's take them one at a time, starting with negligence, because it's the oldest doctrine on the list and the easiest to understand. Did somebody fail a duty of care? If you deployed an AI system and skipped the basic homework and didn't test it properly, didn't monitor what it was doing, didn't put anyone in a position to catch it going wrong, that's not a technology failure. That's the same negligence claim that existed before the AI showed up, pointed at a new tech revolution. Then there's product liability. And this one just got sharper teeth. The EU's product liability directive extends strict, no-fault liability to software and AI across the entire supply chain, including third-party developers, not just the company that deployed the system. Strict. No fault means you don't even have to prove someone was careless. If the product caused the harm, that's enough. That's a meaningfully lower bar than negligence, and it's already in law in one major jurisdiction. The third approach is risk-based, tiered liability, the model that the EU Parliament and a lot of legal scholars are actually favor going forward. Strict liability for what they call high-risk AI operators, fault-based liability for low-risk users, and the tiebreaker for who's on the hook isn't who wrote the code. It's whoever's best situated to prevent the injury and the benefits most from the system. For most of us, that's not the vendor who sold you the AI tool. Courts benchmark reasonable against industry standards, specifically NIST, CIS critical securities controls, PCI-DSS, and FTC guidance. DLP is a named control in most of these frameworks, so its absence is directly citable evidence against you. Before I go further, I need to back up, because I've been saying DLP like everybody already knows what it means. It means data loss prevention. It's a set of tools and practices that track sensitive data, customer records, credentials, your intellectual property, and control where it's allowed to go. It's not a single tool. It watches data in three stages: sitting in storage, moving across the network, and actively being used at an endpoint. Think of it less like a lock on a door and more like a chain of custody that follows the data everywhere it travels. And here's the piece most operators have never heard of, but it's exactly where it's heading in the next 6 months. MCP, or Model Context Protocol-based architecture. Notice the middle word in that MCP, context. Here's the distinction that matters. Information is the raw stuff, a record, a data point, a signal that's true, whether or not anyone's asking about it. Context, on the other hand, is what turns raw information into something you can actually use. Keep in mind, the same information can mean two completely different things depending on the context. Take timing as a context, for example. A set of numbers pulled at the start of the year tells you one thing. The same numbers pulled at the end of the year or right after some catastrophic event tell you a completely different one. The information didn't change. What it means does. MCP's whole job is providing context to AI models so they can generate better outcomes. Every successful AI agent story you've heard about doing real work is because of the quality of the context it's given, which is how well that model actually understands the task in front of it. That's what context means. The protocol doesn't decide what's allowed in the context string. Something else has to do it. For the sake of conversation, let's call it the MCP metadata architecture. It's not a tool you can currently buy off the shelf. It's 3 components that are in the prototype stage. There are dedicated identity sitters that author least privilege security policy. Identity providers manage security credentials for users and control identity federation services so that you can continue to use your current identity provider. So if you are using AWS Cognito, Google Sign-In, and Microsoft Enter ID, formerly Azure AD, the third component is a MCP metadata registry. It's unique to the MCP metadata architecture and provides guidance to the agent about which MCP server is best equipped to satisfy its request for context. Here's the part that should get your attention. MCP's own security documentation says in plain language that the protocol has no built-in controls against data exfiltration and unauthorized transfer of data out of the system or network, unauthorized access, or data misuse. That's not a bug someone's going to patch at the end of the week. That's a design consideration. Every one of these stages where the protocol moves data through where the app sits, how it connects, how the message travels, what tool sends back, has to have that user-defined health check. Nobody shipping anything performs that check for you. And this isn't just one vendor trying to sell you something. In June of this year, NSA and CISA, the same people who tell the entire federal government how to secure their systems, put out joint guidance telling anyone running MCP to route their outbound traffic through a filtering proxy or an enterprise DLP tools. When the government's own security agencies are putting a control on a checklist by name, that's not a nice to have anymore. That's the new floor. Now let's talk about how the world has recently changed. The issue of negligence just changed with the introduction of Anthropic's inference hooks. Claude Enterprise just shipped it in beta. They are synchronous webhook checkpoints that routes every governed tool request to a set of DLP tools and an go, no-go verdict before the inference runs. Mind you, this is inbound, not outbound. Outbound's a lot different. It even may take a different path, especially through the MCP metadata architecture. So you get a go, no-go on your MCP server request. It doesn't shape the response that the MCP server returns normally. It's not automatically looking inside the message response and saying, on the second thought, you're not allowed to see all of this information. This is a trap a lot of executives fall into, waiting for the regulators to finish the rulebook before they act. The courts aren't waiting. They're looking for test cases and applying doctrines they already have to whichever AI case lands in front of them. That's how courts work when they're forced into new tech landscapes. The rulebook you need to worry about isn't the one that's coming in the near term, 18 to 24 months. It's the one that already exists. And you take your chances on how well your situation fits. Why does this matter? It reminds me of something that Boris Cherny said about building AI applications. He said, you build them for where the model will be in the next 6 months, not for where it is today. So you've got to survive 6 months with poor market fit. However, once the model catches up, you'll be 6 months further down the road to the next checkpoints. For businesses deploying MCP servers now that handle PII, credentials, or intellectual property, the emerging position across these sources suggests that DLP tools are close to being recognized industry standard, control for AI, MCP data flows, and it's not theoretical. The major DLP vendors are already racing to cover MCP specifically. Right now, not deploying it starts to look less like a discretionary choice and more like a documentable gap against the reasonable care benchmark, particularly if a breach occurs and the harm traces back to your use of unmonitored tool responses, the ones DLP tool sets are designed to catch. Now, I want to be straight with you about something, because I don't want you to oversell DLP. Everything I've walked you through covers one specific way AI goes wrong: data moving somewhere it shouldn't. It doesn't cover an AI system making a bad call with no data loss at all. Recommending the wrong maintenance schedule, misreading compliance requirements, giving a technician bad guidance, that's still AI wrong, and DLP won't catch it. What we've described is more of a context issue or product design flaw. The reasonable care logic, did you build the case that you took this seriously, still applies. The specific control just isn't DLP for that failure mode. So don't let a good answer to one problem convince you that you've covered the rest. So what do you want to do with this information on Monday? 3 things. 1, find out if you already have an MCP server or AI agent touching PII, credentials, and your own IP. A lot of operators don't know the answer to that yet. Number 2, ask whoever built or sold it whether there's a DLP control watching what the tool sends back, not just who's allowed to log in. Those are 2 different questions, and most people only ask the first one. Number 3, write down what you find even if the answer is we don't have one yet. The reasonable care case isn't built by building perfect today. It's built by being able to show you knew there was a gap existed and that you had a plan for how to fix it. If an AI agent makes a bad decision that causes damage or, more regrettably, harm in your plant, in your fleet, on your hospital campus, don't start by asking, what did the AI do? No legal personhood. So it's never really about the AI. It's about whether your organization has a reasonable care case sitting on the shelf before the incident happened. Can your team coherently discuss how DLP works in your organization? Show where AI tools actually move data. Build it before you need it, not after. The market fit may not be right today. However, 6 months from now, when things really ramp up, you won't be caught looking around for what to do next.